Welcome to another episode of Unraveling Intellectual Property with Michael Stein. Today I have back Cassadee Wellings. Previous podcast, she, uh, or wait, what did we do the last time? Oh, I interviewed you. Now you're going to interview me. Today we're going to be talking about, you tell me what we're going to be talking about.
We're going to be talking about the hidden costs of delaying IP protection. So, our first question for you is when you think about businesses that wait too long to file, what's the very first risk that comes to mind?
I would say losing rights. uh, Particularly when it comes to patents and trade secrets. Uh, with patents, if you have offered for sale, actually have sales, if you've published something, then in the United States, you've got a grace period of 1 year to file a patent application. I've had clients come to me or potential clients and say, I've got a great idea, this and that and the other thing. And then I ask, well, have you exposed it to the public? Have you offered it for sale? Oh, yeah, I've been selling it for 3 years. Too late. It's gone. You have no patent protection. Therefore, that's a biggie. In other countries, if you did want to file overseas, most other countries don't have a 1 year grace period. Some have a 6 month grace period, and it's not nearly as generous. It's only for certain circumstances. And some countries are absolute novelty, so that if you haven't filed first, you lose all rights overseas. So I would encourage businesses, you have an idea, you have a new product, contact an intellectual property attorney first before you actually do something and act upon it. Another risk is with trade secrets. If you have some know-how, you've got an invention, you would like to keep it a trade secret, but you don't take any active steps to do that. And thus, it's commonly widespread throughout the company. You accidentally release it. People don't know that it's a trade secret. Once a trade secret is disclosed in a general sense, you don't take the right procedures, the trade secret's lost. It's gone. You've got nothing. With trademarks and copyrights, a little bit different because you get rights from the time of actual use.
Okay, that's very helpful information. I guess to go into another question is we just talked about your very first risk that comes to mind. What are some less obvious costs that you see that people might not expect rather than just like losing the right altogether?
Yeah, let's take trademarks for instance. You don't think about doing a trademark search. You don't think about seeing what someone else has done. I mean, it's a big world. There's billions of people in the world. There's lots of people having businesses. There's lots of people selling products. If you don't do a comprehensive search, it's very possible that you're infringing someone else's trademark. It could be something they're selling online. It could be something they're selling in stores. It could be something that they're doing uh, just through their domain names, for instance. And thus, if you don't consider your trademarks from the get-go, you could lose, or not, you could lose rights. You could be infringing someone else's. Also, from a business perspective, even if you're not infringing someone's trademark, you may pick some name, but someone else has the domain name and you don't have access to that domain name. So you're looking at it from not just a trademark matter, but you're looking at it from a business matter. It'd be great to have both the trademark and the domain name so that someone can find you easily. And therefore, waiting for the trademark side, you can have potential infringement or lack of ability in some respects to use the mark.
Okay, that's very helpful. You're talking about infringement. What are some potential circumstances or consequences one might face if they were to potentially infringe on another person's trademark? or patent?
That could be very expensive. So, I mean, even just responding to a complaint and filing an answer, it takes not only money, but it takes time. And if it proceeds, you're going to have to gather a lot of information because they're going to file requests for interrogatories, and the third party is going to file a request for documents. Perhaps you'll have to spend a lot of time on negotiating with them to try to come up with a settlement. It could get very expensive. So you might want to consider from the get-go, how do I avoid that possibility? You're never going to totally avoid. People can sue anyone at any time, but if you use foresight, you can do the searching, whether it's patents or trademarks. Consider before, I mean, people when they set up their website, sometimes they buy it from a third party and there's images in there that are copyright protected. And I've had clients be threatened or getting requests for money because even though they bought the copyright package from a third party, a fourth party will say, okay, but the images in there are copyright protected. Give me money. And thus, when you're starting a business, it's helpful, or from the early stages, consult an intellectual property attorney. Let them know what you're doing. Try to avoid the issue in the first place. You may want to consider contacting another party and saying, "Hey, I'd like to do this. Can we work out some kind of licensing agreement or royalty agreement, or just advising them? Uh, I'm not sure if you want to tell them, "Hey, I'm going to be doing this. I'm not infringing." Be affirmative in that regard, but to know the risks is to help minimize the risks.
Thank you. And lastly, for all our people out there seeking any type of IP protection, what are some tips or tricks you might tell them to do prior to actual filings, just to make sure that they are covering all their bases?
Uh, You need to consider the technological issues. Let's say you've got computer software. How protectable is it? What do I get if I go for filing a copyright? You're always looking at what the costs are versus the benefits are. So
Sabrina?
sometimes you may say, it's not worth it. And sometimes I tell a client, you're not going to get much protection from copyright. Um, you may want to consider design patents or trade dress. And with design patents, you could potentially, going back to the patents, you could potentially lose rights. Graphical user interfaces. People don't even know what components of their products are protectable. Or do I file a design patent application? Do I file a trademark application? Can I file both? Uh, and for me, I kind of need to ask a lot of questions when I'm starting something, even if it's like a construction project on my house or doing a renovation or whatever, and what are the potential downfalls and how much is it going to cost? What's the potential if I don't do this? What do I lose? Uh, do I keep the know-how as a trade secret? Do I seek to follow a method uh, uh, patent on that? So much of the world today is software. There's multiple ways to protect that. You sell a product, you have to think about what the market is going to be, what platforms am I going to sell it on, how am I going to promote it, whether I file a patent application, policing third parties, make sure that they're not infringing. If you have a trade secret, taking the proper steps to protect it, making sure that your employment contracts, making sure that you actually own the intellectual property and not the employees. whether they get compensated for contributing, when can they use the intellectual property for their own purposes? Universities get into that a lot. Professors, what do they own? Do they get a share of royalties? Do they get a share of the licensing? What if they do things on their own time? Even when it comes to business formation, how to put the intellectual property, who owns the intellectual property? Is it the individual? Is it the corporation? Do you set up an LLC within the corporation? There's just so many factors that if you wait too long, uh, partnership agreements, uh, you wait too long, it's like, oh, darn, I wish I did that. I wish I had consulted you earlier. I get that kind of frequently.
I could imagine. Well, thank you so much. And for all those tuning in, remember protect your IP rights today at Stein IP.
All right, Cassidy, thank you for those wonderful questions. I appreciate it. And thank you for being an intern here. And to all my viewers, thank you for tuning in to another episode of Unraveling Intellectual Property with Michael Stein. Till next time.